Oh, there we go. Okay. I was having mic issues earlier, and now I gotta do this video again because for some reason my mic sounded like I was, I don't know, a demonic robot or something. So something happened with the connection. I don't know. So this is my second time doing this, but first time for you to watch it. So here we go. This is an update for Delphi, the Delphi case where we go through legal documents and proceedings here. And we've been following what's been going on with the court case between Andrew Baldwin and Bradley Rozzi, who are the attorneys for Richard Allen in the Delphi case. And now they have an attorney that is defending them for this contempt hearing that is scheduled for Monday, which is next week. Today is Thursday as I'm recording this, so technically they really only have less than a day and a half to prepare for this now, and they probably don't have a whole lot of clarity as to what is going on at this hearing because that's kind of how Judge Gull has been. She's been providing them just with these quick little minute orders that will say denied without hearing, and there's no reason and there's no justification as to why she denied anything, and it's not the way you're supposed to do it. You have to have some kind of law backing up why you are choosing whatever choice you make. So, that being said, there were several filings, 6 to be exact. We're going to go through all 6 of them. Well, I actually went through one of them already, so we'll just kind of review it. But so 6 documents came out on Tuesday of this week. This is Thursday, so now we're 2 days away from, a day and a half away from the weekend, and then Monday's going to be here in the blink of an eye. So here is the first filing I'm going to read to you. A list of additional witnesses and exhibits for contempt hearing. We actually did go over this in one of my other videos because I had a bunch all in a row, and this one I had before any of the others. So the witnesses: Stephen Wood, Angela Sidlowski, Julie Melvin, Terry Williams, Courtney Parsons, and Matt Hoffman. And then down here, there's a bunch of exhibits that they are going to be using that include this person, Gary Baudette, who is AKA Fig, AKA Fig Solve. I don't know anything about him or her, probably him. I don't know anything about that, but I'm assuming it's a YouTube creator. And so there's communications between Gary Baudette and Prosecutor McClelland, multiple, it says multiple, and then there's also communications from Baudette about Prosecutor McClelland. So he was talking about McClelland to people. What was he saying? Then they reference a bunch of other things like certain videos, episodes of videos or whatnots. Sergeant Holman's communication with a Terry Williams and or secret keeper. So Sergeant Holman, who is investigating the case, is communicating with a YouTuber about it. A lot of YouTube people here. An email exchange between Judge Gull and Attorney Rozzi regarding accidentally misdirected email. That's going to be part of their Baldwin email to Judge Gull. All right, so finally, I just wanted to read this last section. On or about February 29th, 2024 and March 1st, 2024, the defense received an anonymous call from a woman in Texas claiming to have approximately 240 pages of leaked documents and agreed to provide them. The defense has received only a few of those documents, all of which appear to be available to the public. The defense also discovered information from the prof, claiming that he had delivered 2 pounds of documents to the Indiana Attorney General. The defense is continuing to investigate that claim, which may result in additional exhibits, should you find any. All right, so now the next filing I'm going to read is a nice, oh no, not this one. The next one is nice and short. This one is a motion to stay all ancillary proceedings and get this case to trial. So all this other stuff that we're doing, it's just wasting time. Richard Allen's attorneys have already put in the speedy trial motion, and it has been granted, as it should, because Judge Gull had no recourse to not grant it. So she had to, and it's now the first day of trial is scheduled for May 13th. And we know that that's not a lot of time to prepare for a trial, especially when they just received all the discovery again, attorneys Baldwin and Rozzi. So they have to go through everything again, which they've been doing. But they've gotten a lot of information back, and some of it, might not be what they had before. Some of it might be snuck in, some new stuff. So who knows? They still have to go through all of that discovery. So, anyways, so this is a motion to stay all those ancillary proceedings. So everything going on with this trial or this hearing for Baldwin and Rozzi, it's a waste of time. Let's get to the trial, because that's what's most important. The girls are what's most important. Justice for the families. Justice for Richard Allen. If he didn't do it, we need vindication for him to be free. We need these things to happen in order for our justice system to work. However, McLeland and Gull are all caught up with these other things going on, trying to make it look like they're contemptuous and acting in ways that they shouldn't be, and it's just not true. So anyways, let's read on. Comes now David R. Hennessy, counsel for attorneys Baldwin and Rozzi, and respectfully moves the court to stay all ancillary proceedings and get this case to trial. In support of this request, counsel states, 1. Currently pending is a hearing on March 18th, 2024 on the defense motion to dismiss and the state's hope to punish the defense counsel. So, yeah, the state just wants to punish us. We want the motion dismissed. All right, so number 2, the motion to dismiss directly affects the case and the prospect of trial. The state's request for the court to punish defense counsel does not. Beautifully said. Number 3, the state's request to punish defense counsel includes alleged acts and omissions over a year old. The state did nothing about its complaints until the day after the Supreme Court reinstated defense counsel. Exactly. Number 4, the contempt hearing has already required many hours of preparation, will require many more, and the hearing itself will last at least 1 day and probably 2. This is just a distraction for everyone from preparation for a trial now 61 days away, and at this point it's even less. It is also a disservice to the families involved. Exactly. Number 5, since the prosecution delayed as long as it did before seeking contempt sanctions, clearly time is not of the essence. There is no reason not to prioritize trial over the ancillary questions of contempt. Any such issues should be litigated and resolved after trial, no matter the outcome. Number 6, in short, the court and the attorneys need to get back to the critical issues and stop the diversionary filings. I love it. He's telling you, hey, court, judge, knock it off. Get to the stuff that matters. All right. Wherefore, counsel respectfully prays the court to stay all ancillary proceedings not directly related to those charges, evidence for trial, or other trial issues. So, let's table all of this. All this conversation about contempt and misconduct, let's just table it, and we can get to the trial first, which is of the utmost importance, and then we can get to all this other stuff, no matter what happens in the trial. Here is a motion for specific findings of fact and conclusions thereon, and this is great because Judge Gull keeps giving her little minute orders with no reasoning. So this is basically tying her hands to giving us a reason. You have to, what's the word I'm looking for? My brain just had it and now I lost it. Not verify, but you have to provide, oh my God, brain. You suck sometimes, brain. Anyways, you need to be able to verify and provide case law. That's not what I was going to say, but that's about what I was going to say. All right, back it up. Back it up with case law. So, motion for specific findings of fact and conclusions thereon. Defense counsel Andrew Baldwin and Bradley Rozzi, by counsel David R. Hennessy, respectfully request that this court issue findings of fact and conclusions thereon with respect to the contempt proceedings scheduled for hearing on March 18th, 2024. In support of this motion, defense counsel states the following. This is the short and sweet one. Number one, and just one. Indiana Trial Rule 52A provides that upon the written request of any party filed with the court prior to the admission of evidence in a case where issues are tried without a jury, the court shall find the facts especially and state its conclusions thereon. Wherefore, defense counsel by counsel respectfully requests that this court issue findings of fact and conclusions thereon regarding the contempt proceeding scheduled for hearing on March 18th. So we want reasons. We want your conclusions. We don't just want to hear denied without hearing. We want a reason why you denied it. And if it's a good enough reason, I mean, it might not be a good enough reason. So we need a reason why. The next motion is an objection to change of venue. Comes now counsel for attorneys Baldwin and Rozzi and objects to the change of venue from Carroll County to Allen County. In support of his objection, counsel states, this case was commenced with the filing of a charging information in the Carroll County Circuit Court. So the information, it's called an information, which I don't know. It's like a hearing. So this hearing that they're going for contempt, I guess, is it was started in Carroll County. So why would we go to another county, Judge? Number two, all pleadings in this case have been filed in the Carroll County Circuit Court, including the prosecution's verified information for contemptuous conduct, which got us here in the first place. Number three, there has been no motion for change of venue filed by either party. Number four, there is no basis provided by statute or case law for a change of venue upon the appointment of a special judge. So remember, Judge Gull is appointed. She's an appointed special judge, but that doesn't give her special rights. Number five, the Honorable Frances S. Gull was appointed as special judge in the Carroll County Circuit Court for this cause. Her authority in this case is only pursuant to that appointment. So she shouldn't have authority for punishing Baldwin and Rozzi either. All right, number six. Therefore, no charges pending against Mr. Allen there are no charges pending against Mr. Allen in Allen County. So why would you have your trial in Allen County? That's where she's from. And the judge is supposed to come, when you have a special judge, the judge comes to you, not you go to them. It's not vice versa. Like when they pull in jurors from out of town, they usually bring them in. They don't go to them. Anyways, so there are no charges pending against Mr. Allen in Allen County. Number seven, the appointment of a special judge does not transfer a case to the judge's home county. Transfer is only allowed pursuant to Rule 79M. Additionally, Rule 79N states, in pertinent part, all hearings involving in-person testimony by witnesses shall be conducted in the court where the case is pending unless A, the parties and the judge agree otherwise on the record, or B, the hearing is not before a jury and the special judge determines that exceptional circumstances exist such that the matter can only be heard in a timely fashion in his or her own county. So she's going to make probably some kind of, well, I can only fit it into my Allen County calendar. I can't fit it into this calendar or whatever. I don't know. She's going to come up with some BS excuse. The defense has not agreed, and there are no exceptional circumstances. So those are the only two exceptions, and she doesn't qualify for either one of them. So she really doesn't have any say in where the proceedings take place. Number 8, upon the appointment of a special judge, the elected clerk and court staff of the originating county remain. So all of the clerk and court staff that are in Carroll County would remain in Carroll County. It's just Judge Gull that's coming in. And that's probably what she doesn't want. She probably wants her people, her stuff that she can control. So she wants it in Allen County, I guess. That's what I'm assuming. But she doesn't have any right to do that. It says right there. There are no exceptions, and the defense definitely does not agree. So, number 9, conducting proceedings in Allen County imposes a hardship on attorneys and witnesses. Respectfully submitted. All right, the second to last one, a verified petition for recusal of prosecutor from contempt proceedings. Comes now, attorneys Baldwin and Rozzi by counsel and respectfully petition the court to recuse Prosecutor McClelland from any contempt proceedings. In support of this petition, counsel states, number 1, on January 29th, 2024, the elected prosecutor of Carroll County filed a verified information of contemptuous conduct. Number 2, all of the alleged acts or omissions in that pleading are more than a year old. Number 3, that pleading was filed the day after attorneys Baldwin and Rozzi were reinstated as appointed counsel for the accused. Number 4, Mr. McClelland made no effort to seek punishment for defense counsel in the intervening 1 year. So why now? Just because you want them off the case, it seems. Number 5, whether defense counsel were disqualified or not, if Mr. McClelland truly felt that they should be punished for acts and omissions, he would have filed his pleading sooner. Number 6, the facts and circumstances of the filing, the delay, the timing, and the allegations all indicate a personal, vindictive attack on defense counsel or ulterior purpose. That filing also does not comport with the rules, statutes, and case law regarding contempt proceedings. Because remember, we read in, I think it was his motion to dismiss the charges because they were filed under Richard Allen's case file number, same docket and whatnot, and it should be its own separate file, its own separate thing. It should be, the state of Indiana versus Baldwin and Rozzi, not the state of Indiana versus Richard Allen and Baldwin and Rozzi through him. You know what I'm saying? It doesn't make sense that the way that they did it, and it was incorrect, and they just didn't care. And Judge Gull was like, well, I'm not going to dismiss it because I already put it on the calendar, so it would be inconvenient to hit that cancel button. Cancel meeting. Number 7, the allegations are frivolous and unfounded. There's like a bunch of car noises outside. Sorry, guys. The allegations are frivolous and unfounded. Number 8, Mr. McClelland accessed, read, and quoted a defense pleading that was filed ex parte. And if you followed along with me in my other filings, Delphi filings, I did do a brief description of what ex parte is. It basically just means for one party, not the other. So if you file a motion, if the defense files a motion and says this is ex parte, it means your eyes cannot look at this, Prosecutor Nick McClelland. This means you. You can't look at it. And what does he do? Mr. McClelland looked at it. So, Mr. McClelland's theory on one of his accusations is that the defense counsel should have voluntarily communicated with him and the court an accidentally misdirected email. Andrew Baldwin accidentally emailed the wrong Brad in his, he probably typed in Brad and it went to a different Brad. And it was basically just a list of exhibits. It was like nothing. So nothing was leaked. Like they're saying it's some accidental leak or something, but it was nothing. Yet he did not voluntarily report that he had accessed an ex parte pleading. Nick McClelland did not. All right, so despite Mr. McClelland's protestations of an innocent mistake in a later filing, no other attorney of record could access that pleading. B, the CCS clearly stated ex parte, which Mr. McClelland would have seen before opening the document, and it was in the title. Mr. McClelland is a lawyer with nearly 15 years' experience and knew or should have known that ex parte means not to be accessed by or shared with opposing counsel. And E, Mr. McClelland, having opened the pleading, would have seen the title, which specified ex parte. It's very clearly in the title, but he read it anyway because he quoted a portion that was deep within the document. The concept of innocent mistakes by attorneys will be part of the evidence at any contempt hearing. Damn. He's basically saying right there, very snarkily, like, okay, if you want to bring up these supposed leaks, we've got proof, Nick McClelland, that you have been part of the leaks. Basically is what they're saying. And you've been playing your part of like reading these ex parte motions and not following suit. So you're part of the problem, Nick. And we're not going to let that slide if you're going to be after us. So it's good for the goose, good for the gander. All right, so number 11, Mr. McClelland had communications with the person that had confidential information which they publicly disseminated and claimed who their sources were, but Mr. McClelland did not report that information or direct anyone to investigate it. Those exchanges will be evidence at contempt hearing. 12. Prior to filing his request for contempt, Mr. McClelland had not received or reviewed all of the results and interviews related to his accusations. This will be part of the evidence at the contempt hearing. So anything you've done, Mr. McClelland, it's going to be out there at the contempt hearing. So if you want to bring contemptuous misconduct charges against someone, just be prepared what might come out in trial then, or in the hearing then, I guess. Mr. McClelland was present at unrecorded conferences with the court that impact his allegations and will be part of the evidence at any contempt hearing. He will be called as a witness to corroborate the testimony of other witnesses. Number 14, Mr. McClelland will be called as witness at any contempt hearing. He has been so advised, yet has not withdrawn as counsel for the state for any such hearing or designated either of the two other prosecutors or the case to litigate his contempt allegations. Wherefore, counsel prays the court to bar Prosecutor McClelland from participating in any contempt proceedings. So he knows he's going to be a witness. They've told him, they've informed him, we're calling you to the stand during this hearing. And McClelland, it's a huge conflict of interest. He can't be a witness and prosecuting the case. So he needs to recuse himself, and he hasn't yet. Thus far, he's still the attorney on record, and they're going to try to get him to be barred from the proceedings as anything other than a witness, which I'm all for, and I can't wait to see see these hearings and the trial and all of it, but I doubt we're going to see any of it. I don't think there's any cameras at this hearing anyways, so we wouldn't see it, but it's just crazy that all this is going on. This is all unprecedented, by the way, if you're new to true crime or not. I mean, none of this stuff, I've never seen anything like this. In this case, in the Karen Reed case, there's just so much corruption going on. All right, so the very last filing that I'm going to be reading is a verified petition for recusal from contempt proceedings. So let's begin. Comes now attorneys Baldwin and Rozzi by counsel and respectfully petition the court to recuse herself from any contempt proceedings. In support of this petition, counsel states this. So they want her off. We have asked her, or not we, but they, the defense team has asked her to recuse herself now, I think twice or something. I can't remember, but she's not leaving. And now they're saying, well, you have to at least recuse yourself from these contempt proceedings because you're very biased. And here's why. On October 8th, 2023, by email, the court made inquiries about and suggestions for law enforcement's investigation of a reported leak of discovery material subject to a protective order. Number 2, in that email, the court sua sponte offered to use its contempt power it did not have under the circumstances to assist the investigation by compelling the cooperation of recalcitrant content creators. So she's making these content creators on YouTube comply with her order to provide whatever it is that she wanted. I'm not sure what she ordered, but part of all of those exhibits, I don't know. All right, so number 3, the court's initiation and participation in the investigation give rise to the appearance of a lack of neutrality and independence. It appears that you're not neutral. So if it appears that way, you need to recuse yourself. Number 4, the court instructed defense counsel that they were expected to cooperate with the investigation, which they did. This was further involvement in the investigation, further involvement that Gall put herself in. So she might be making herself a witness too. The court has received much information from the attorneys and other sources concerning the leak and may or may not be admissible in a contempt proceeding. Recusal is appropriate to avoid the possibility and appearance that the court is considering events outside the evidence and testimony actually presented at a contempt hearing. Number 6, without having heard any evidence and without even having reviewed the documents sent in an accidentally misdirected email, the court has already expressed its judgment that the misdirection of the email was an egregious error. That's a great point. It is therefore at least appears that the court has prejudged the contempt allegation by the state regarding the misdirected email. Just like I said, it almost seems like Judge Gull and Prosecutor McLeland planned something or something. I don't know. It almost seems like they're in on it. I don't know. 7. More generally, the court previously not only criticized the same defense attorneys for the same conduct now alleged by the state to be contemptuous, it also coerced them into withdrawing their representation of Mr. Allen for that conduct. Again, there is at least the appearance that the court has prejudged the state's contempt allegations. I want to back up to this sentence here about coercing the defense counsel to withdraw their representation of Mr. Allen. Not only is she interfering with his right to a lawyer, and a lawyer, it doesn't necessarily have to be a lawyer of your choosing, but he found some lawyers that he really liked, and they liked him, and they believed in him and his innocence, more importantly. And we need more defense attorneys like that. Anyways. But there's the appearance that there's a bias there. So number 8, defense counsel will be offering admissible evidence that Gary Baudet, aka Fig Solves, a person who has involved himself in this case on the internet, claimed to have received and disseminated confidential documents, and that his source for the documents was an employee of the court. Protesting too much, Mr. Baudet has now written a fawning letter to the court denying allegations that have not yet even been made. Under the circumstances, with the allegation of court involvement that will not go unsubstantiated, the court should not be ruling on the admissibility defense counsel's evidence regarding Mr. Baudet and his activities, much less assessing what value to give it. Number 9, counsel for the state accessed and in a filing with the court even quoted an ex parte motion filed by defense counsel. DocsPop has confirmed that the ex parte pleading was correctly filed as confidential. The Carroll County Clerk's Office has confirmed the ex parte pleading was only shared with defense counsel and the court. So if defense counsel didn't leak it, the only other person who had it was Judge Gull and her staff, I should say. So it doesn't necessarily have to be her that leaked it. It could be someone on her staff as well. But still, they're the only 2 parties in possession of this, and it gets leaked. So one of the court's staff has reported that they thought a confidential filing applied only to the public and not counsel for the state. Evidence about access to the ex parte pleading will be presented at any contempt hearing. So you want to say my clients are in contempt, however you say it. I'm going to show you at the contempt hearing how you're in contempt. Okay, because it appears that the state's access to an ex parte pleading was enabled by the court's staff, whether due to improper training or through ignorance, the court should not preside over any contempt hearing. Agreed. The court conducted its own investigation of the leak and lent itself and its powers to the investigation conducted by others. As a matter of public record, the court at least appears to have prejudged almost all, if not all, of the state's contempt allegations against defense counsel. The involvement of the court's staff will now be the subject of any contempt hearing. So, if your staff leaked these photos like we think they did, or if you, Judge Gull, leaked these photos like we think someone from you or your staff did, then that there needs to be some accountability for that. So they're going to bring it up at the contempt hearing. Anything and everything is coming in against you guys. So if you want this battle, be prepared that we are ready to fight you back with throwing your own words in your face, pretty much. That's what I'm getting from this. Under the totality of these circumstances, the court cannot appear to be a neutral and detached arbiter of the state's contempt allegations, and accordingly, the court should recuse itself from those contempt proceedings. Wherefore, counsel for defense counsel respectfully prays the court to recuse herself. I agree. She should not be a special prosecutor or a special judge in this case. I don't think we need one. Why should we have to have one? Just get a judge in that Well, I think maybe because it's such a small county that the other judge recused himself because he knew someone or one of the witnesses involved or something. I don't remember, but it did eventually get moved to Frances. I thought her middle name was Siegel. Anyways, so that is it for these filings from David Hennessy. It's going to be interesting to see um, what Judge Gall responds with. This is not the first time they've asked her to recuse herself, and I don't think she's going to do it. But, maybe third time's a charm, hopefully. I think she should. I think it's what's best for the case. I think if she wants any kind of justice for those girls, she should, because I don't think she's going to give a fair trial. So that's my opinion. I just am giving you my opinion on the things that I see and observe in these filings in the case and whatnot. So let me know in the comments below what you think. Do you think that Judge Gall is going to recuse herself? Do you think she's going to recuse Nick McClelland, the prosecutor, the DA in this case? Let me know in the comments below what you think about that, and I will talk to you later. Take care. Thanks for watching. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.